Hello everybody and welcome to another KN Talks video. This is another one of our occasional series of discussions of issues of US law which might be of interest to people thinking about relocating their business to the US or starting up over there. Today I'm delighted to be joined by Chris Pesch from Levenfeld Pearlstein in Chicago. Chris is one of Levenfeld's top experts on US securities law, and he's going to talk to us a little bit about the things that you might want to consider if you're trying to raise money in the US or from US persons. Chris, thanks for joining the podcast. Perhaps you could start by telling us a little bit about yourself and your firm.
Sure. So first off, John, thanks for having me on. I really appreciate it. And I've been practicing securities law for over 25 years. I've worked in large firms and in-house at public companies in the United States. So I have a broad experience representing issuers and purchasers of securities in the U.S. and also representing foreign purchasers of securities in the U.S. and have represented foreign private issuers, which are foreign companies based outside the U.S. that list their securities on U.S. exchanges. So happy to provide some background on the U.S. securities law, my favorite subject.
That's great. So maybe we should start with kind of a broad outline because securities law often varies a lot between jurisdictions. So perhaps you could just explain a little bit what the base regime is.
Sure, absolutely. Well, the United States has multiple regulators for securities law. Everybody knows about the federal government through the Securities and Exchange Commission. And under the Securities Act of 1933, all security sales in the United States have to either be registered, that is registered with the SEC, or subject to an exemption from registration. So there are various exemptions from registration. The most common exemption is for private placements under Section 4A2. Whereas if you don't advertise or make what is a public offering, you can offer securities without registration. What most people outside the U.S. don't realize is that each individual state also has a securities department and also has securities regulations that you have to comply with. And that varies from state to state. You have some states where there's a lot of securities transactions, such as New York and California, that have relatively onerous schemes requiring registration at various levels and a limited number of exemptions from local registration. The great news for issuers of securities is that the SEC through Congress has created a safe harbor for certain private placements that preempt state law. So that you can do, if you fit into this safe harbor under what's known as Regulation D, you can do a securities offering to accredited investors. That is essentially somebody who the SEC has determined can take care of themselves, right? I mean, the SEC has this role of encouraging securities transactions, but also protecting consumers. So they create this definition of accredited investor that says, okay, these people have the money, so the net worth where they can lose their investment and not be really harmed. They also have the knowledge to make an informed decision on their own or can gain the representation or hire people to help them make an investment decision. So they create this kind of accredited investor definition. So under Rule 506B, under the Securities Act, issuers in the U.S. can essentially offer an unlimited amount of securities in a dollar amount to accredited investors, people that meet that definition. And all they have to do to get around state securities laws is file a Form D with the SEC, and also there's a central filing service that you pay a fee and you deliver that Form D to the securities department in each individual state, and it gets you around a lot of the onerous state regulations. Although New York State for years has argued that they can still impose their own extra regulations, but unless you're doing real estate transactions in New York State, it's probably something that you can ignore. I mean, it's never been litigated, but people still bring that up. So most security private placements that people in the UK would be looking at or overseas would probably be under Rule 506B.
And so to be an accredited investor, what kind of income or net asset level are you looking at?
Well, you essentially have to make as a couple, 300,000 a year, as an individual, 250,000 a year. You have to have net worth, not including your home, of $1 million, or you can have expertise in the area. For example, if you're making an investment in a candy factory and you've been a professional candy maker your entire life, you could probably you probably qualify under those regulations. But most people use the financial regulations as a test. The SEC has recently tightened things up a little bit. You have to, used to be people could just kind of represent in the placement in the security sales agreement that they were accredited investors. Now there's a questionnaire that you have to fill out, so you tick off the box as to how exactly you qualify. And under certain circumstances, you need to provide accountants' letters and other things like that showing that you meet the requirements.
Okay, that sounds quite similar to how it is in the UK, actually, for our certified high net worth exemption for financial promotions purposes. Where the levels are a bit different. So we'd be looking at £100,000 for income and £250,000 for net assets. They did try and increase those limits back at the start of the year, but there was such an outcry from the startup community that they ended up putting them back. But we also have the tick box. What we don't, I think, tend to have is that concept of having to have knowledge and experience. So what kind is that the kind of knowledge and experience you'd have as like a relatively sensible middle-class person who reads the business pages of the newspaper, or is it a more onerous kind of?
No, it's more onerous than that. I mean, it's usually applied in the States to people that actually work in the business, right? So somebody's like a vice president of the business. They don't make enough money. They don't have enough net worth, but they still want to invest in the business that they work for. And so those people are considered to be accredited investors for purposes of the rule. I mean, I have seen it used on occasion for people that have considerable experience in the space, right? I mean, it's, sometimes an ex-employee of the business wants to invest, but they work for the business, or somebody that somebody knows that has that kind of knowledge and experience. But most of the time, those people aren't in a position to invest a lot of money, so it only comes up rarely. I've seen it come up in people trying to raise money for like a microbrewery to make beer, where they have some friends that are beer makers, and they bring those guys in and say, well, we could call these guys accredited investors because they run their own microbrewery. And I said, that would probably work, but it's you want to be a little bit careful with that particular point.
I guess with the state preemption, it's much easier to be able to point to a financial limit and say we obviously satisfy it than try to argue the toss on somebody's knowledge and experience of a particular industry.
Much more black and white, and say, hey, here they are, they meet the criteria, they've checked this box, we've checked them out. We have, you don't have any reason to believe that, their representation isn't correct. I mean, you have to be a little bit careful. I mean, if, you're doing these private placements as an issuer and somebody, you get a representation from somebody and, their best friend calls up and said, oh, I hear Bob's in the deal. Well, great. Well, why is, Bob, Bob doesn't have any money. How do you become an accredited investor? At that point, you probably have to do a little bit more diligence on Bob before you let him in, but
yeah.
So it's not just simply check the box and then put the blinders on. So the SEC is making people work a little bit harder on that.
So if you are trying to raise money in the US, being aware that regulation is a thing and you need to comply with it, what steps should you be taking to make sure that you are complying? Obviously, I guess come and get some advice in the first instance.
Yeah, I think that if you're contemplating making an investment in the U.S. and you don't really have a presence in the U.S., seeking counsel would be very useful, right? I mean, you have people that have access can review the offering documents and make sure that they're complete, make sure that they're in compliance, that there aren't any lawsuits out against these individuals, that they're not on any lists of people that are that aren't supposed to be dealing in securities. I mean, there's been plenty of syndications, especially in real estate and crypto lately, where people have raised a lot of money and then ended up just with what was essentially a fraud, and so then they get blacklisted, and then a lot of those people will reach out, try to raise money extraterritorially, right? Reach out to people outside the U.S. to try to raise money, and so hiring an experienced securities counsel or an accountant that deals in this space, is very interesting information, can save a lot of money in the long run. the diligence that a professional in the States can do quickly and efficiently, is, protects the investor. And then, you need to review the documents. I mean, the documents in private placements range dramatically from almost public offering type documents, right? With a full prospectus, with risk factors, financial statements, all of those things. And a subscription agreement with comprehensive representations made by the issuer. I mean, there's certain things that you want to make sure that the representations that are made, just like in the UK, you want to make sure that securities issued are fully paid and non-assessable, right? There's not they're not going to be able to come back at you for additional funds on those securities. So you want that representation. You also want to make sure that the company's in good standing and all of those things, and so you want to understand that, and then so you go from that gamut, which is the complete document package, to a PowerPoint presentation and a relatively skimmed down subscription agreement with what we call a big boy clause, a clause saying, hey, you've had the opportunity to ask all the questions you ought to ask, you're capable of evaluating this investment, and if you lose all your money, it's you can sustain that loss. So, that's a wide gamut of offering documents, and they all carry their own risks.
And from an investment raising company, I guess that you will want to make sure that you're placing yourself in the right position, because there's no point doing a massive quasi public offering pack of documents for a little startup fundraise and spending a lot of money. You need to get the right balance for your fundraise and for the investors that you're targeting, which obviously the likes of you, Chris, could help give people who don't necessarily have experience of US market practice the right guidance on.
Yeah, I mean, the guys of the very startup nature, those guys will be the PowerPoint presentation and big boy clause, because they don't have anything yet, right? The financial statements they'd be ashamed to show that at this point, because it's all losses, right? So it's all the concept, the idea, and what's going forward. The large packages tend to be maybe private equity funds or businesses that are looking for maybe a final round before a liquidity event, either a sale to a private equity firm or going public, and those will have audited financial statements. The pricing will be completely different, right? I mean, if you're coming in a later round than an earlier round, because the risk profile is different.
That's great. That's really interesting. And obviously, there are a lot of issues. It's not just Reg D that you'll need to be complying with when you're raising money. That just that ticks one box, but you do need to make sure that you're having regard to all of the other applicable law as well. Right?
Absolutely.
Right. Well, Chris, that was really interesting and really helpful. Thanks again for taking the time to talk to me. Obviously, anybody who is thinking of raising money in the US or investing money into US person is looking for some legal advice should get in touch with Chris. He and his firm are excellent and can help guide you through the process, making sure that you get the right level of protection and that you can cover the legal elements of properly raising money so you don't face any issues down the line. Chris, thanks very much. Hope to speak to you again soon.
Oh, thanks for having me on.
It's a pleasure. And of course, as ever, please do subscribe to our YouTube channel if you are interested in this. We are producing a number of videos on US legal issues, as well as those relating to the UK and other jurisdictions around the world. So hopefully there'll be some things of use and interest to you there. Goodbye.